Good morning. Bonjour. Buenos dias. Buongiorno. Guten Morgen. And Dzień dobry. Now you see why I'm a lawyer and not a translator. It is a great honor to be here in Poland. I've been here about a week, and I've come to really love the Polish people, the Polish culture, the beauty of your country. So it's a great honor to be here. A couple days ago, I'm staying at the Sofitel Hotel. A couple days ago, I walked over to the Tomb of the Unknown Soldier, which is a very beautiful monument with the soldiers guarding it. And I have been to the Tomb of the Unknown Soldier in the United States. It is very impressive with the soldiers. But, you know, the history of the United States, we are only a country for 236 years, which in Western history is a pretty short time. So I was very impressed to see 1,000 years of Polish battles in history, honoring the soldiers who fought, and especially happy to see the tribute to King Sobieski, who won the famous Battle of Vienna, protecting Western civilization in a very critical moment. I've always studied that in history, and it was great to see. And so I thought to myself, well, perhaps coming out of this conference, Poland will once again offer something in the defense of Western civilization. So very glad to be here. I'm going to change a little bit the topic that is on the brochure, primarily because of the time limitations that we have. So I want to just bring your attention for your further reflection on two very important presentations given by Pope Benedict XVI, but not because of the religious implications. Obviously, he's the Pope, but because he makes a profound point about law and about the crisis of the philosophical framework for Western civilization. So the first presentation I would like to bring your attention to, and you probably have read this already, was the Pope's address to the German Parliament about a year ago, which I thought was very important and given, at least in the United States, almost no coverage. You had to go look for it. Plenty of coverage about movie stars, but nothing about this, what I thought was this is our culture. He said that unlike other monotheistic religions that undergirded civilizations, Christianity has never said there was a revealed positive legal code that came down from heaven. Rather, in Christian civilizations, countries influenced profoundly by Christianity, the West. And here I mean the West in not a traditional sense. To me, Russia is part of the West in the sense that it is an Orthodox country. It's influenced by Christianity. He says, in Christianity and those countries influenced by Christianity, we look to reason and nature for helps and guidance in coming up with a positive law, not simply revelation. This is a profound point because we have lost the sense of the fullness of reason, which leads to the next presentation, which I strongly urge. I run in, let me tell you a little bit about myself before I continue. I am the president and founder, I'm an attorney, a lawyer in the United States. I have founded the Bioethics Defense Fund. We are a public interest law firm. That is, I do pro-life law full-time. This is all I do. I do it in the United States, around the country. I do it all over the world, full-time. We raise money. We're a nonprofit, which means I have people with little cups outside of churches. No, it's not kidding. But we raise money. And it allows me the great privilege of fighting for life full-time. Okay. And these are the issues that we deal with. We draft legislation, we litigate cases, and we do lots of public education. And part of the public education that we do is I'm able to speak not just at conferences like this, but I go specifically and especially to law schools and to medical schools. Because on all the bioethics issues, whether they're abortion or cloning or embryonic stem cell research or euthanasia, at the heart of these issues, there is a doctor or a nurse, a medical professional, not just the law. So we try to go and help them think through these theoretical issues, which takes me back to the second presentation of Pope Benedict, which was the presentation at Regensburg in 2006, which was grossly, I believe, mischaracterized as an attack on Islam, when in fact the Pope's address is only about 10% of that topic. What he was really talking about, which is the philosophical crisis of Western civilization, is the problem of reason, okay? This truncated, restricted, narrow understanding of reason, so that reason is either seen as subordinate to this kind of theological voluntarism. God's will is all important. Profound thing about the West is we understand that faith and reason work together. Okay. The other problem, of course, is in the modern scientific world that reason is only restricted to practical reason. So all the metaphysical, profound speculation about what it means to be a human being. This point that the Pope makes to the German Parliament, that you have to look to human nature and to reason, okay, is missed. And so our law, all across the West, suffers from this. Okay. Now, I'm going to try to give you some context using the American experience, but the examples I have selected, I believe, are universal in its application. So I hope you forgive me for using American examples, but I think the lesson is something that we can all understand. So there are many causes of the culture of death, and I don't mean to suggest that there's only these three, but I want to kind of give you a flavor. This is also the kind of thing we do in law schools and medical schools, and I will make this point especially to the young law students and the young lawyers. If there is a way that you can dedicate your practice to fighting for a culture of life, I would strongly encourage it. I know the systems and maybe the cultural understanding of giving, it might be different in the West, different parts of the West. But if you can do that, if you can dedicate your life, it is no more nobler cause and incredibly fulfilling. I was in private law practice in Arizona for 4 years, and it was very lucrative. I made a lot of money, but this is what I get up in the morning for. So I want to start, why do we have now these cultural conflicts in the West in the last 100 years, okay, in ways that we didn't have them before? Well, I want to point to a quote by a British historian from the mid-30s of the 20th century, Christopher Dawson, who said, excuse me, I'm going to read it. I'll read it from here. The sphere of action of the state has grown steadily larger until it threatens to embrace the whole of human life and to leave nothing whatsoever outside its competence. 100 years ago, you could, or 200 years ago, 300 years ago, you might be forced to pay taxes and you might be conscripted into the army, but most of the time you didn't run afoul of the government. The government didn't have this huge regulatory reach that it does now. But of course, today we have that problem. So I want to go ahead and just click the first one. This is this quote from Pope John Paul II. As history demonstrates, a democracy without values easily turns into open or thinly disguised totalitarianism. You will forgive me, but I want to read the fullness of this quote, which I don't have here. My apologies. So it's somewhat long. I won't read a lot of quotes this long, but I think it's very important. This is John Paul II, in 1991, his encyclical Centesimus Annus, paragraph 46. Authentic democracy is possible only in a state ruled by law and on the basis of a correct conception of the human person. Nowadays, there is a tendency to claim that agnosticism and skeptical relativism are the philosophy and the basic attitudes which correspond to democratic forms of public life. Those who are convinced that they know the truth, for instance, abortion is a moral atrocity, and firmly adhere to that belief, are considered unreliable from a democratic point of view, since they do not accept that truth is determined by the majority, or that it is subject to variation according to political trends. But if there is no ultimate truth to guide and direct political activity, then ideas and convictions can easily be manipulated for reasons of power. As history demonstrates, a democracy without values easily turns into open or thinly disguised totalitarianism. Okay. And of course, he goes on to make the point that democracy stands or falls on the values that we share. We used to share values in a way we don't anymore. And then, of course, the latest, we are building a dictatorship of relativism. Relativism keeps coming up. The idea that we are the autonomous person. I think it was the professor who said, you know, to people like Peter Singer and others, there's nothing inherently worthy of a human being. We are simply biochemical machines, and we move through space. Think of Hobbes. We're matter in motion, and that's all we are. Okay. Okay. Now, this is a quote I'm going to show you in a second from St. Thomas More. Okay. Now, all law, well, I'm talking to lawyers, all law has a coercive element. But in 2,500 years of Western history, the question is, what is the essence of law? Is law simply coercive will? Or is there something more? Well, as we'll see, someone like Thomas Aquinas, there's only two views of law, ultimately, fundamentally. Law is simply the will of the legislator, whether that legislator is the emperor, or the king, or the legislature, or the parliament, or something more. And I would point to you to question 90 of the Summa, where Thomas Aquinas gives a very succinct but very profound answer. He defines law, fundamentally, as an ordinance of reason. Here's that word reason again. For the common good, made by one who has care of the community, and promulgated. But fundamentally, it's an ordinance of reason, which means if it doesn't correspond to something higher, something more transcendent, it's not law. It's force. It's an act of violence. But it's not law, fundamentally. Okay? Think about the Nuremberg Trials after World War II. Okay? Was this simply the victorious Allies inflicting the victor's justice against the defeated? Or was there something more? Now, you can go back in Western history. You can look at Thucydides in the Peloponnesian War, where he discusses the Athenians. They go up to the island of Milos. They're fighting, the Athenians and Spartans are fighting this 30-year war. The Melians are allies of Sparta. The Athenians say, you have one option, surrender and be a slave. The Melians, understandably, say, maybe we are not going to submit, maybe we'll just be your friend. And the Athenians said, you don't have that option. And the Melians made an argument, this is unjust. And the Athenians, in a comment that echoes down to this day, this is one view, not the right view, but one view. The Athenians said in response, the weak suffer what they must, the strong do what they will. Is that all this Nuremberg was? Was it simply the victor's justice? Or Plato, when he writes in the Republic, Socrates is having a debate about the issue of justice, and his interlocutor is Thrasymachus, and Thrasymachus says, there's no such thing as justice. Justice is whoever has the strength, is the interest of the stronger. Okay? No, I would submit to you that the Nuremberg Trials were an understanding that law has to be reason. Because what was the Nazi defense? The doctors, the Nazi judges, the Nazi officers who were tried. I was, what? Simply following orders. Another way of saying that is I was following the law. The law of the Third Reich required me to do this. And the Nuremberg Trial stands for the proposition that there are some things, no matter what the positive law says, you can't do. You cannot do it. It may look like law. It may have the form of law. It may be issued by the lawmaker, but it is not law. It is not law. When you gas a 4-year-old girl because she's Jewish, and you burn her body in the gas chamber, you have to know in your heart, in your mind, that this is not law, whatever the positive law says. Okay? Now, here's the quote from Thomas More. He starts out, he says, this is his trial. Now that the court has determined to condemn me, God knoweth how, I will discharge my mind concerning my indictment in the king's title. The indictment is grounded in an act of Parliament which is directly repugnant to the law of God. In his way, it's a violation of reason. He says, as anyone who has ever conscientiously objected has said, I am the king's true subject, and I pray for him in all the realm. I do none harm. I say none harm. I think none harm. Someone who conscientiously objects, a physician who says, I will not do this abortion, is not harming anyone. He's simply saying, I will not violate my conscience. Nevertheless, Thomas More went on to say, it is not in the supremacy that you have sought my blood, but because I would not bend to the marriage. Okay. All the attacks on conscience in the Western world, and there will be more, okay, are because someone will not bend to the realm of abortion on demand, cloning on demand, euthanasia on demand. Now, legal positivism is another big problem in the Western world. This is Justice Holmes. He said, I always say, as you know, that if my fellow citizens want to go to hell, I will help them. It's my job. Okay. Okay. And now I'm going to point another more profound example from American history, which many of you may know, the Dred Scott decision. Now, if you want to understand something about the United States, and I was a proud American born in the United States, you have to understand that slavery was the original sin, in a sense, if you could use those terms, of the founding of America. America was a great experiment on profoundly noble ideals, but there was a problem. The southern states had had slavery for 180 years, 160 years before the Revolution. And the southern states did not want to give up slavery. So the Constitution embodied slavery. It didn't really deal with it. Okay? So Dred Scott is a slave. His master brings him from the south up to the north, and he sues when he gets to the free states. He sues for his freedom. And he makes an appeal, goes all the way to the United States Supreme Court, and this is the way the court framed the argument. The question is this. Now, listen when you read this with me. Listen to the language of commodity. They're talking about a person, but it sounds like a thing, a product. Can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States? Answer? No. They had for more than a century before been regarded as beings of an inferior order and altogether unfit and so far inferior that they had no rights which the white man was bound to respect. He was bought and sold and treated as an ordinary article of merchandise and trafficked whenever a profit could be made. Now, when I go to law schools and med schools and I show them this now, everyone is appalled. They're horrified. You know, Just like you think about the Nazi atrocities or any kind of horrible, the communists, whatever, you are repelled naturally. And I say to those same students who are very much modern students, they are very much relativist. Of course, everyone is a relativist. There's no truth. And I say, will any of you tell me that this decision was right, or that today in the 21st century slavery is a good thing? And even though they're all relativists, no one puts their hand up. Okay. The court went on to say, it is not the province of the court to decide upon the justice or injustice of the policy or the laws. Okay. But there was a dissent in Dred Scott. I show it to you to say there's always the light of reason and reality in these things. This was Justice McLean in dissent. He lost the argument, but he says, a slave is not a mere chattel, not a mere property, not a mere thing. He bears the impress of his maker and is amenable to the laws of God and man, and he is destined to an endless existence. In other words, McLean recognized this being has a soul. This is a book which I strongly recommend if you have not seen it, by Professor Hadley Arkus of Amherst University. It is, I believe, the leading book on jurisprudence in the United States. Okay? And you hear many times, I don't know if you hear it in Poland or the rest of Europe, but you hear it many times in the United States, there should be no, like Justice Holmes, no relationship between law and morality. They're two separate things. But in this book, Professor Arkus says, when we invoke the language of morals, we move away from statements of personal taste and private belief. We offer a judgment about the things that are universally right or wrong, just or unjust. And once we are clear that the logic of morals must incorporate the sense of a true judgment that is universal in its reach, the connection between the logic of morals and the logic of law virtually establishes itself. Okay, we'll pass this. Now, I will give you one concrete example, one more, and I test your patience, and I hope this is helpful. After the Dred Scott decision, and before the election of 1860 that brought Abraham Lincoln to the presidency and sparked the American Civil War, the bloodiest war we've ever fought, Lincoln had a series of 7 debates in the state of Illinois. He was running for the United States Senate seat from Illinois with Judge Douglas, a very famous politician. And here was the issue. In 1803, the original 13 colonies that became the American country, President Jefferson purchased from France territory in North America that doubled the country overnight. It'd be like if Poland, immediately got, say, Germany, and just doubled, huge, huge territory. The question was, as people went into this new territory, were they going to be forming states that were free states or states that were slave states? Because the South was very concerned about balance. And Judge Douglas said this: when people go into the states, they can vote. And I don't care whether they vote slavery up or they vote slavery down. I don't care. I just want them to have the right to choose. Words like that. Very similar to today's abortion debate. Lincoln said this, very famous response. When Judge Douglas says he don't care whether slavery is voted up or down, he cannot thus argue logically if he sees anything wrong in it. He cannot say that he would as soon see a wrong voted up as voted down. When Judge Douglas says that whoever or whatever community wants slaves, they have a right to them, he is perfectly logical if there is nothing wrong in the institution. But if you admit that it is a wrong, he cannot logically say that anybody has a right to do a wrong. Okay. Now, I have some copies I will hand out after my talk. This is a publication a few years ago by a PhD biologist at the University of Utah, definitively establishing, absolutely, unequivocally, that a new human being comes into existence at the moment of sperm-egg fusion. Okay? When the other side argues, oh, you're using religion, or you're using philosophy, or you're using whatever, the answer is no. We start first, as the Pope points out, when you're making law, you look to nature and you look to reason. What do nature and reason tell you? What they tell you is you have a new human being. And I will have a number of copies for you, and also you can go onto our website and you can get a copy of this off our website. Okay? Very helpful in these discussions. Okay. Now, one more example from American history, very outrageous, of legal positivism, the idea that law and morality are separate. In America, in the 1920s, eugenics was very big. You heard this yesterday. And there was a young girl. Her mother was considered an imbecile. Now, that was a created term. There was no meaning behind it. It meant someone who was promiscuous, sexually promiscuous. And this young girl was described as sexually promiscuous. She was in her early 20s. And they were worried that she would have children and they would be sexually promiscuous. I always say, if the issue is sexual promiscuity, then many university students are in danger of imbecility. So this issue went to the Supreme Court. Justice Holmes, our friend, who said he would be happy to help his fellow citizens go to hell, said in this, he upheld the forced sterilization of this young girl. And this is the argument. We have seen more than once that the public welfare may call upon the best citizens for their lives. What he is referring to was he fought as a young man in the Civil War, and he's saying that societies sometimes ask people to make the ultimate sacrifice, okay? Which is true. He says it would be strange if it could not call upon those who already, now listen to this language of eugenics, those people who sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent us from being swamped with incompetence. Complete disdain for these people. It is better for all the world if, instead of waiting to execute degenerate offspring for crime or let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes, and then he says 3 generations of imbeciles are enough. Okay, very shocking. Even more shocking is this case has never been overturned by the United States Supreme Court. I talked to you about Nuremberg. The American prosecutors at the Nuremberg Trials were worried because they said, you know what the Germans are going to say in defense? The Nazis are going to say in defense? We learned this eugenics from the Americans. And you know what? It was absolutely correct. I just want to make the point about higher law, well, however you want to, whether you want to call it natural law or whatever, that this is not a Christian concept. Okay? This is something that before the Christian era, 2,000 years ago, people understood this. The most classic example is Cicero, 55 BC. True law is right reason in agreement with nature, universal, consistent, and everlasting. There will not be one law at Rome and another at Athens. I like this because I'm Greek and Italian. There will not be one law at Rome and another at Athens, or different laws now or in the future. There is now and will be forever one law, valid, and for all peoples and all times. Whoever does not obey this law is trying to escape himself and to deny his nature as a human being. When Professor was talking about Peter Singer and all those who have this eugenic and utilitarian outlook, they are denying the reality of their own human nature. I always say, though, when you have these people who get up and publicly say atheism is the right way or utilitarianism is the right way, I read somewhere, I don't know if this is correct, that when Peter Singer's mother was dying, he did not euthanize her. And when they asked him, now, this could be completely wrong, you check this out, this is why Google exists. But my understanding was when they asked him, why did you not euthanize your mother? This is what you talk about. His response was, she was my mother, which is the good response, right? But I don't think that the people who talk about relativism all the time or atheism live this way. I always tell the students, challenge that. You go home and you have your food tester taste your food that your wife prepared because everything is relative and she could decide to kill you today. No one lives this way. The last part is that's the theoretical that we do. How do we bring it to the practical, to legislation? In America, you heard yesterday, abortion has been imposed on us by the court. All we can do is try to carve out safe areas and to make arguments that help women and babies both. This part of the talk is usually given by my colleague. Her name is Dorinda Bordley. You would all love Dorinda. She lives in New Orleans, Louisiana. She's married with 4 children. And as a woman, she's very successful. I always say she is the greatest woman pro-life lawyer in the United States. And then she always says to me, why do you qualify it as woman? Why aren't I the greatest lawyer in the pro-life lawyer in the United States? And I say, because my ego is too big to admit that. But Dorinda usually gives this presentation, and here's the point she makes. You heard the radical feminist argument, right? The radical feminist argument is women cannot be equal if they cannot control their fertility. I'm going to, this is the very infamous language of the Supreme Court, reaffirming the right to abortion. Now, on the one hand, it says, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and the mystery of human life. On one hand, we would say, well, we don't want the government telling us where to go eat, where to buy a house, right? We don't want that. On the other hand, if you take this to its full extent, it's absurdity. My place in the universe is to kill all of you. Would that be good? That's how I find meaning and purpose. Well, no society can function if you take it to its extreme. Here's what the court said in the United States. And I think it's very much like the argument around the world. I was just in Australia and New Zealand, and it's the same kind of argument. The court said, since Roe v. Wade, this is now almost 20 years. This is 20 years ago, but it was talking back 20 years past that. People have organized intimate relationships. This is a code word for sex. Sex. They have engaged in sex and have made choices that define themselves in reliance on the availability of abortion if their contraception should fail. But ultimately, what the court says is abortion is not some great fundamental constitutional right. It's simply super contraception. If your pill fails you, you abort your child. Then the court went on and made this connection. The ability of women to participate equally in the economic and social life is facilitated by their ability to control their reproductive lives. And so my colleague, Dorinda, asked this question. In the United States, we had the suffragette movement, the movement for women's rights. Women were second-class citizens. They were chattel. Not as bad as slaves, but they did not have equal rights. And women began to organize in the 19th century. So we asked this question. Is it true that women have to be able to kill their child to be equal? And so we asked the question, did the original women's rights advocates equate equality with abortion? And there are 3 very famous women's advocates in the United States history. So we looked at what they said. Susan B. Anthony. It, meaning abortion, will burden her conscience in life, it will burden her soul in death, but oh, thrice guilty is he who drove her to the desperation which impelled her to the crime. Elizabeth Cady Stanton. When we consider that women are treated as property, and they were, it is degrading to women that we should treat our children as property to be disposed of as we see fit. And then, maybe the ultimate, Alice Paul, she was the organizer of the Equal Rights Amendment. Abortion is the ultimate exploitation of women. Okay. Whatever the modern view by the modern feminist, radical feminist position, this was not the position of those who fought for equal pay and the right to vote and equal dignity in the marketplace and workplace. Okay. This is Professor Mary Ann Glendon of Harvard Law School, head of the Pontifical Council on Social Science, the Beijing delegation, the U.S. ambassador to the Vatican, very accomplished. To earlier feminists, she said, who had fought for the vote and fair treatment in the workplace, it had seemed obvious that the ready availability of abortion would facilitate the sexual exploitation of women. In the United States, one of the most vigorously supportive pro-abortion segments of society are young males, 18 to 30. I leave it to you to figure out why. To the United States Supreme Court, this is how a woman in a crisis pregnancy, this is how she thinks. This is the court's model. The woman finds out she's pregnant. She does not want to be pregnant. She coolly, she rationally looks at all of her options and she says, abortion, this is what I choose. That's how the court looks at it. What this woman, Frederica Matthews Green, studied. She went all over the United States and she interviewed women who had had abortions. These are post-abortive women. And she said to them, why did you have an abortion? Basically thinking she was going to hear, I'm my autonomous woman, it's my right, who are you to tell me I can't do this? But what she found out, as she says, in the beginning, I assumed that women felt driven to abort because of either material needs, you hear this all the time, they're poor, housing, medical care, job security, child care, that sort of thing. I was surprised that these problems were relatively minor in the decision-making process. Far more significant were problems with relationships, particularly with the father of the child and with the women's parents. I discovered that in almost every case, a woman chooses abortion to accommodate the wishes of others who do not welcome her child. So, when the man who got this woman pregnant, whether it's the father, the husband, whatever, you know, any of horrible situation, and says, here is your money, you make the decision, is your right. The woman doesn't necessarily see this as empowerment. She sees this as abandonment. Oh, you will not be there for me. So, most common reasons for choosing abortion: the husband or the boyfriend pressured her to have the abortion. Parents pressured her. 6 out of 7 times it was the mother. I was in abortion litigation years ago, a young girl, and I was taking her deposition, asking questions under oath, and I said, how many abortions have you had? She was probably 20 years old. She said, I had 3 abortions. And I said, and we were talking about how she got to the abortion clinic, and every time it was her grandmother who drove her there. You know, it's not the picture you have of grandma. Women wanted to protect parents. Husbands or boyfriends were weak and unsupportive. Okay, on and on. Now, the idea that abortion is good for women and empowering for women is directly refuted by now in the United States 40 years of medical evidence. This was a meta-analysis by Professor medical doctor John Thorpe at the University of North Carolina Medical School. He heads the Women's Research Center, very prestigious medical school, very prestigious. This research, okay, the idea that abortion is helpful for women, this is a good, empowering thing. The medical research is very strong. Your placenta previa increases 50%, preterm birth 30%, maternal suicide 3 to 6 times, 300 to 600%. Okay, and breast cancer. Now, I'll make this point about breast cancer. There's a debate whether if you have an abortion, it directly causes a woman to have breast cancer. That is a debate that's still going on, even in the pro-life movement. But what is not debated, what is acknowledged by, in the United States, the National Cancer Institute is this. If a woman's first pregnancy goes all the way to term, she gets a natural protective effect as the hormones that allow her breast to develop to provide milk for the child. As that process goes all the way through maturation, there's a natural protective effect. If your first pregnancy ends in an induced abortion, not spontaneous, but an induced abortion, you lose the natural protective effect that most women get. That is undisputed. So, I want to show you, and I have some copies. In the United States, my colleague and other people throughout the years have passed informed consent. Now, we obviously think abortion is a grave moral evil, but we can't end it as long as the Supreme Court forces it on the country. So, we have created a law, and others have also, that require the abortion provider to give women information. Because if we're going to say that women should be treated with dignity, then they should be treated with dignity to be given the full information about these issues, not what the abortion provider only wants to provide. So, this is an example of a Louisiana brochure. Every woman going into an abortion clinic in Louisiana is given this. It has fetal development in 2-week stages. It has the risk, the description of the procedure. It has places to go for if you decide you want to hold your child, keep your child. Okay, the father's duty. Just because the father says, I will pay for the abortion, doesn't mean he can get out of any responsibility. These are things that are essential in trying to get women to understand you have other options. Now, we went further, and I have some of the brochures also. Last year we went further. Not only are you required to give this in Louisiana, but we have what we call signs of hope. I will pass them out if you're interested. It requires this sign to be posted in every abortion facility in the state of Louisiana, in the waiting room and in the procedure room. It says 4 things to the woman. You can't be forced to have an abortion. It is unlawful for anyone to make you have an abortion against your will, even if you are a minor. We get lots of information, anecdotally, that people are not always free to make this decision, that there is a lot of coercion going on. You and the father of your child must provide support for the child, even if he has offered to pay for the abortion. You and adoption lays out those rights, and you are not alone. If what drives many women, contrary to public opinion, is this sense of abandonment, then it is essential for women to know that in a crisis, there are people who will help you step by step by step, through the birth and after the birth. And we lay out all this. This is a website that is not a pro-life website. This is a website by the Endowment for Human Development, and it has live video. Anyone in the world can go, if they have access to the internet, can go and click and see a developing child at any stage. It's very powerful because, like ultrasounds, when women see the reality of what is in their womb, it's hard for them to say, this is not a human being, this is not me, this is not somebody alive with dignity and a right. Very powerful site. And here's my final, and I promise this is the final thing. Okay. And this is, now I speak not as a lawyer, I speak as a human being who sees the assault on life as a tragedy for our civilization. And as an encouragement to you. I hope it's an encouragement to you. In the United States, when Roe v. Wade 20 years later was reaffirmed, many people gave up. 20 years. Forget it. We were never, and now it's 20 years past that. So now we're 40 years. And a lot of people say we're never going to end abortion. But I want to encourage you that in democracies, where you don't impose on people, you propose ideas, and then you make arguments. That it takes time, and that you have to be willing to be steadfast with fortitude. Because I will show you this. From the first slave who came to the New World in 1619 to the end of the American Civil War was 246 years. From the end of the Civil War to 1964, where there was this very important Civil Rights Act, was 99 years. In the United States, in 1896, we had a decision of the Supreme Court that said you could have separate facilities. You had the black water fountain and the white water fountain, the black bus and the white bus, the black school and the white school. It took 58 years to reverse that. My encouragement to you is that there is no more important right for civilization than the fundamental right to life. It is worth fighting for. It is worth giving your all for. It is worth teaching your children and your grandchildren, or their grandchildren, to keep fighting. And that is what I have to say. So thank you very much.